Hello and welcome to the Velvet Gavel Case Files. I'm your host Anca, an inquisitive musing on a legal journey, and I am absolutely thrilled to have you joining me with this deep dive. My mission here is simple: to make South African laws accessible, engaging, and easy to understand. We are going to be looking at the changes on the law, the how, the why, and the when, so you can navigate the legal system with confidence. For now, we will be focusing on the laws for children. Today we are starting at the very beginning, the single most important principle governing every single matter concerning a child. It's the fundamental rule that is, quite frankly, like the law's boss. We are decoding the best interest of the child principle as set out in Section 7 of the Children's Act. To grasp this concept, I want you to think of the law as a legal garden. This legal garden is the ecosystem designed to help every child flourish. And the guiding principle in this garden, the one that decides how much water, sunlight, and support that precious plants get, that is the best interest of the child. This whole system is anchored naturally by the 5 roots of the Children's Act, which are the fundamental rights guaranteed by Section 28 of the Constitution. So let's roll up our sleeves and dig into the soil, because you can't truly appreciate the garden without knowing what the soil is made of. We start with the origins. In the 20th century, we were deep in the weeds of the Roman-Dutch legal tradition, heavy influenced by the English law, such as the Guardianship of Infants Act of 1925. In this era, child-related matters were dominated by parental authority. The child's welfare, if it was considered at all, was often secondary. I mean, it might sound harsh now, but the attitude was one of ownership. The whole legal perspective leads us to the fundamental question: is the child really just the property of a parent? The good news is that the legal system eventually realized, maybe not. The best interest of the child principle as a firm concept were firmly and formally established through the case in the mid-20th century. The courts gradually began to intervene mostly in cases of neglect and abuse, but critically the main concern was still not the best interest of the child. Then came the case where the gavel first made the major noise. Case file Fletcher versus Fletcher in 1948. This was a custody dispute following a divorce. The court, very boldly for that time, ruled that the best interest of the child are the first and paramount consideration. This was the pivotal moment, the seed of change that established the principle in South Africa, telling the old law to move aside. However, and this is important, while the Fletcher judgment established the principle, it did not provide the detailed criteria for what constituted to be the best interest. It was a powerful new rule without any practical rulebook. The takeaway from this historical look is that the child law moved from a parental authority focus to a child welfare focus, confirming that the child's well-being is the very beginning and development of the law today. Now we move into the modern era. With the new democratic order, the 1996 Constitution came into effect, bringing with it a fundamental change. The best interest principle was made a fundamental right in Section 28 of the Constitution. This is the part where our pretty legal garden began. How do we interpret this powerful, broad principle in the court of law? Before the Children's Act, the courts relied heavily on a tool emerged from the case of McCall versus McCall in 1994. The McCall list was devised primarily for use in custody battles. It is sought to provide the factors to consider when deciding who get custody, which back then was often awarded to the innocent spouse. McCall declared the best interest of the child to be a dominant factor, which is a huge step forward. But the McCall list had its limitations. It included elements we now cringe at. And while it included child preference, it was a list designed for a different time. It was a good starting point, but it was not exhaustive, and the court could essentially consider any other factors they deemed necessary. This then paved the way for Section 7 of the Children's Act. This is the official guide to decoding the best interest of a child. The courts have been very clear that the best interest of the child principle should not be applied to a predetermined formula. It's like the exact opposite of planting wild flowers. So, in this case, we need to cultivate and care for this little plant. The environment should be tailored to the little plant's needs. Section 7 is now the chief and the paramount consideration in all matters affecting children. Let's look at why is the superior tool compared to the old McCall list. So, the wider application, Section 7 applies equally to the caregiver or the relevant person in the child's life, not just the biological parent. It sets out crucial factors that must be considered. Section 7A stipulates the importance of a child-parent personal relationship. It does not specify the ability to provide economic security as the only factor, but rather emphasizes the child's intellectual, emotional, and spiritual well-being and stability. It also includes the child's maturity and development stage as to a criteria to consider when taking a child's wishes into account. This is a more nuanced approach into asking a child for a preference. There is a separate self-standing act that states that every child must be given the opportunity to participate in proceedings. While the views might be considered under the obligation of Section 9, the court retains the power to consider all the relevant factors. The courts have ultimately held that all the relevant factors in Section 7 must be considered, but they are not limited to those factors. This ensures that the principle is always flexible enough to serve the child's individual best interest in any unique situation. It confirms that the child's well-being truly trumps any outdated rules. Now that we know the how in Section 7, let's talk about the why, the high level of goals of legislation. After all, the law has clearly evolved from seeing a child as property to seeing them as a person deserving of protection. Let's look at the object of the Act, what the Children's Act aims to achieve. To promote the preservation and strengthening of families, to give effect to constitutional rights of children, to fulfill the Republic's international duties regarding children's well-being, to provide services and support for children's healthy growth in body, mind, and emotion, to build strong community systems for care and protection of children, to protect children from discrimination, exploitation, and all forms of harm. To give care and protection to children who need it the most. To recognize and support the special needs of children with disabilities. To promote the overall safety, development, and well-being of children. To be clear, the underlying rule here is, if all else fails, the Constitution takes the win. So this leads us back to the legal garden and the ultimate anchors for the system. The 5 roots set out in Section 28 of the Constitution, the top 5 rights a child has. For better understanding, think of a child as a seed that is planted and now needs to grow the best today can be, with all the support they can possibly get. So these 5 roots are the non-negotiable foundations for that growth. The identity root, the family root, the survival root, the safety root, and the freedom root. We will of course be examining all the cases relating to each of these roots in depth in upcoming episodes to gain a full understanding of how they work and how they have tested in a court of law. What you need to remember as we wrap this fundamental discussion up is that the law has moved definitely from a parental authority model to a child-centric one. Here, the best interest of the child is not just a mere suggestion, but politely considered, it's the law's boss. Keep that in mind. We've covered a significant amount of ground today, tracing the evolution of child law from the Roman Dutch traditions to the landmark Fletcher case, through the development of the McCall list and the flexible framework provided in Section 7 of the Children's Act. We have established that the law's boss is a dynamic principle guided by the non-negotiable objects of the Act and anchored by the 5 constitutional roots. This entire legal ecosystem is designed to ensure that the well-being of the children is the first final decision maker. I hope this has helped you to decode these slightly dusty legal concepts. Thank you so much for joining me in my first episode of the Velvet Gavel Case Files. Be sure to subscribe so you don't miss the next episode where we will start to dig into the case law surrounding the 5 constitutional roots. Until next time, keep digging for the truth